Melania Trump's legal catastrophe. Okay, I need you to stay with me here because what I'm about to walk you through is something we almost never see in American legal history. A First Lady of the United States is about to be forced to testify under oath about her marriage, her living arrangements, her tax filings, and her connections to Jeffrey Epstein. And here's the thing that makes this genuinely unprecedented. She did this to herself. Her own legal team made a catastrophic miscalculation, and now there is no way out. This isn't speculation. This isn't anonymous sourcing. This is happening right now in federal court, and the implications are staggering. Let me tell you exactly how Melania Trump walked into a trap of her own making and why even a Trump-appointed judge probably cannot save her from what comes next. Here's what you need to understand about how we got here, because the context matters enormously. Back in October, veteran journalist Michael Wolff received a letter. Now, if you've followed the Trump family for any length of time, you know exactly what kind of letter this was. It was a demand letter threatening a $1 billion defamation lawsuit. That's billion with a B. The letter came from Alejandro Breto, a Coral Gables attorney, who has become Donald Trump's go-to legal attack dog for silencing critics. And the substance of that letter was essentially this: apologize. Retract everything you've written about Melania Trump's connections to Jeffrey Epstein, or face complete financial destruction in court. Now, most people who receive one of these letters from the Trump legal machine do one of two things. They either comply immediately, issuing what Wolff himself described as North Korean-style confessions and apologies, or they go silent and pray the whole thing just goes away. But Michael Wolff is not most people. Subscribe to this channel right now and turn on notifications, because what happens next in this case is going to reshape how we understand accountability for the most powerful people in America. Wolff is a veteran investigative journalist. He's written multiple best-selling books about the inner workings of the Trump White House. He's spent years documenting the chaos, the dysfunction, and the secrets that the Trump family desperately wants buried. And when he received that $1 billion threat, he did something that nobody expected. He sued first. Think about what that means for a moment. Instead of cowering, instead of apologizing, instead of going silent, Michael Wolff ran straight to New York State Supreme Court and filed a preemptive lawsuit against Melania Trump. In that filing, he laid out every single statement her lawyers claimed was defamatory, and he explained in methodical, devastating detail why each one was either demonstrably true, fair, and accurate reporting, constitutionally protected opinion, or taken completely out of context by her legal team. But here's where it gets genuinely fascinating. Wolff didn't just defend himself. He went on offense. He called the Trump legal strategy exactly what it is: a pattern of strategic lawsuits against public participation. In legal circles, these are known as slap suits. Lawsuits filed not to win, but to intimidate critics into silence, to drain their resources through endless legal battles, and to create what Wolff described as a climate of fear so that Americans cannot freely exercise their First Amendment rights. Stay with me here, because this is where Melania Trump made the biggest mistake of her life. Her legal team, rather than fighting in New York State court where Wolff had filed, decided to try something clever. They filed what's called a notice of removal, attempting to move the entire case to federal court. Now, on the surface, this might seem like reasonable legal strategy. Federal court has different procedures, different rules of evidence, and in many cases, defendants prefer federal judges to state court juries. And in a stroke of what can only be described as Trump luck, the random selection process assigned this case to Judge Mary Kay Weiss Kessel. She's a Trump-appointed federal judge in Manhattan. This is the same judge who ruled against Manhattan prosecutor Alvin Bragg when he tried to quash a congressional subpoena. The same judge who denied Columbia University's attempt to challenge Trump administration funding cuts. So Melania got her Trump judge. She got her federal court. Everything should be going according to plan. But here's what most people completely miss about federal jurisdiction. And this distinction matters enormously. To remove a case from state court to federal court, you need a legal basis for federal jurisdiction. The most common basis is something called diversity jurisdiction. What this means in practice is that the two parties in the lawsuit must be citizens of different states. If both parties are from the same state, there's no diversity, and the case stays in state court. Period. Michael Wolff is from New York. That's not in dispute. So for Melania Trump to move this case to federal court, she has to establish that she is not a resident of New York. She has to prove that she's a citizen of a different state, presumably Florida, where the Trump family claims official residence. And this is where the trap snaps shut, because now, under established federal procedure, Michael Wolff's attorneys have the absolute right to conduct what's called limited jurisdictional discovery. Let me say that again so it lands properly. Melania Trump's own legal strategy has now given opposing counsel the right to depose her, to send her written interrogatories, to subpoena her financial records, to demand her tax returns, to ask her about every single aspect of her life that relates to one fundamental question. Where does Melania Trump actually live? If you're finding this breakdown valuable, hit that like button right now, because this story is about to get significantly more complicated, and I want to make sure you understand every dimension of it. Think about all the questions Melania will now have to answer under oath. Where does she sleep most nights? How many nights per year does she spend at Mar-a-Lago versus Trump Tower on Fifth Avenue versus the White House? When did she last spend the night in the same bedroom as her husband? What do her tax returns say about her state of residence? Has she claimed Florida residency for tax purposes while actually living in New York? What about property tax exemptions? The homestead exemption in Florida is substantial, but you have to actually reside there to claim it legally. And then there's the Barron Trump question. Barron Trump is currently a student at NYU New York University, located on Fifth Avenue in Manhattan. Now, NYU charges different tuition rates depending on whether you're an in-state or out-of-state student. The difference is substantial. So what did the Trump family claim on Barron's application materials? Did they claim New York residency to get in-state tuition benefits? If they did, that would directly contradict Melania's claim to be a Florida resident for jurisdictional purposes. Here's where it gets even more revealing. There has been substantial reporting over the years about the living arrangements within the Trump marriage. Multiple sources have indicated that Donald and Melania don't share a bedroom. Reports have consistently suggested that Melania spent very little time at the White House during Trump's first term. She was seen far more frequently in New York City, maintaining her lifestyle on Fifth Avenue, shopping, attending spa appointments, having lunch with friends. During the second term, her absence has been even more pronounced. She's essentially invisible at official White House functions, except for the occasional state dinner. The reporting suggests that Melania Trump lives primarily in New York City to maintain proximity to her son at NYU. She's not shopping on Worth Avenue in Palm Beach every day. She's living her life in Manhattan. And now she has to answer questions about all of it under penalty of perjury. Some might argue that Judge Weissel could simply limit the scope of discovery to protect Melania. After all, she's a Trump-appointed judge with a clear track record. But here's the fundamental problem with that theory. Jurisdictional questions are not discretionary matters where a judge can side with whoever they prefer. The rules of federal procedure are explicit. If there's a legitimate dispute about diversity jurisdiction, the party seeking federal court has to prove their case, and the opposing party has the absolute right to challenge that proof through discovery. Even a judge who desperately wants to help Melania Trump has to follow the law. And the law says that if Wolff's attorneys can articulate a good faith basis for questioning her residency claims, they're entitled to discovery on that issue. Given everything that's been publicly reported about Melania's living arrangements, there's clearly a good faith basis for that challenge. Now, let's talk about the substance of what Wolff actually wrote. Because when you examine the specific statements Melania's lawyers claimed were defamatory, you realize just how weak her position actually is. Statement 1, that Melania Trump was very involved in the Epstein situation. Wolff's defense is that this was taken completely out of context. What he actually wrote was that the First Lady had largely avoided the topic publicly, but was acting behind the scenes. That's not defamation. That's journalism. Statement 2, that Melania could be the missing link in President Trump's ties to Jeffrey Epstein. Again, Wolff argues this was taken out of context and represents fair and accurate reporting based on documented facts. Statement 3, that Melania was involved in Epstein's social circle, and that's how she met Trump. This is actually supported by the historical record. Melania was a model with ID Model Management, an agency run by someone who was friends with both Trump and Epstein. She met Trump at the Kit Kat Club party hosted by ID models. These are documented, verifiable facts. Statement 4, that she was introduced to Trump by a model agent with whom both Trump and Epstein were involved. Wolff says this statement is demonstrably true. Statement 5, that Epstein made certain allegations about Trump and Melania's relationship. Wolff says this statement is also true. Drop a comment right now. Tell me where you're watching from. I genuinely want to know how far this information is reaching, because Americans need to understand what's happening here. So when you put this all together, what you realize is devastating for Melania Trump. She is now facing invasive jurisdictional discovery that will expose her private life. And she's enduring all of this to pursue a defamation case. She's probably going to lose anyway because the underlying statements are either true or constitutionally protected opinion. This is legal malpractice territory. Someone on Melania's legal team should have seen this coming. Someone should have explained that removing the case to federal court would trigger jurisdictional discovery. Someone should have calculated whether the benefit of a federal forum was worth the cost of having Melania answer questions under oath about where she lives, how often she sees her husband, and what her tax returns actually say. But they didn't. Or they did, and Melania overruled them, or they did, and they got it catastrophically wrong. Either way, Melania Trump is now in a world of legal hell entirely of her own making, and the implications extend far beyond this one lawsuit. What happens when Melania testifies about her living arrangements? What happens when she has to explain why she's almost never at the White House? What happens when financial documents are produced showing where she actually claims residence for tax purposes? What happens if there's a discrepancy between what she's told the IRS and what she's telling the federal court? These aren't hypothetical concerns. These are the exact questions that will now be asked, and every answer Melania gives will be under oath, subject to perjury charges if she lies. The question now is whether the Trump legal team has any escape route. Honestly, the options are severely limited. They could try to voluntarily dismiss the removal and return to state court, but that would be a humiliating admission that they made a catastrophic mistake. They could try to settle with Wolf, but he's shown absolutely no indication he's interested in settlement. He wants this fight. He wants the discovery. He wants the truth on the record. They could try to limit discovery, but as I've explained, the rules of federal procedure are clear on jurisdictional matters. The most likely outcome is that this plays out exactly as Wolf's attorneys intend. Melania will be deposed. She will answer questions about every aspect of her life that relates to residency, and those answers will become part of the permanent public record, available for journalists, investigators, and the American people to examine. For Donald Trump, this has to be an absolute nightmare scenario. He spent his entire career controlling information, managing his image, using legal threats to suppress unfavorable coverage. And now his own wife's legal strategy is about to put their marriage, their living arrangements, their financial dealings, and their Epstein connections into the public spotlight. This is the lawsuit Donald Trump feared most, not because of the defamation claims themselves, but because of what discovery will reveal. Let me leave you with three things to remember about this situation. First, Melania Trump's decision to remove this case to federal court was a catastrophic, unforced error. She traded the possibility of a more favorable judge for the certainty of invasive jurisdictional discovery. That's a trade no competent attorney should have allowed. Second, the substance of the defamation claims is remarkably weak. The statements Wolf made are either demonstrably true, protected opinion, or taken out of context. Melania is enduring all of this exposure to pursue a case she's likely to lose. Third, and most importantly, this represents something larger about accountability in America. For too long, wealthy and powerful figures have used legal threats to silence critics. Michael Wolff refused to back down. He sued first, and in doing so, he exposed the fundamental weakness of the Trump legal playbook. It only works if you never actually have to prove your case in court. The moment you enter the legal system, you're subject to its rules. You have to answer questions. You have to produce documents. You have to tell the truth under oath. For Melania Trump, that moment has arrived. We're watching something historic unfold. A first lady facing jurisdictional discovery about her marriage and living arrangements. A preemptive lawsuit that turned $1 billion threat into a devastating liability. A Trump-appointed judge who, despite her track record, may not be able to save Melania from the consequences of her own legal strategy. This is what accountability looks like when someone finally refuses to be intimidated. This is what happens when the legal system works as designed. And this is why what happens next matters for every American who has ever been threatened into silence by someone with more money and more lawyers. Make sure you're subscribed with notifications turned on, because this story is far from finished. The discovery process is just beginning. The depositions are coming. And when Melania Trump sits down to answer questions under oath, we'll be here to break down every word. I'll be watching, and so should